Great. Hi, everyone. Thank you so much for joining us for today's webinar. My name is Dustin Saldarriaga, and I'm a senior associate at Scott Legal PC. Today, we're going to be spending some time talking about the EB-2 National Interest Waiver. And this is a green card option, a very special option because it's not only an underutilized category, but it also is available to those who are entrepreneurs who own their own companies. So this is becoming, as we've seen, more and more popular. It's especially popular for those who are on E2 visas, which some of you may be on. We are very fortunate to have my colleague Jiyae Hwang presenting on the topic today. Jiyae is a senior associate at the firm as well, and she has significant experience preparing national interest waiver applications. A few things before we get started. This webinar is being recorded, and we will be sharing the recording with you later. After this webinar, you will be receiving a link where you can access the recording, as well as a link to the PowerPoint that you see on your screen right now. We'll also send you a National Interest Waiver comprehensive guide, which really does gather the best information that we have on the National Interest Waiver. NIW for short. We'll also send you a link where you can sign up for future webinars. We try to do at least a few of these webinars a month, and they are on a variety of topics. So even though our firm does focus on business immigration, we handle the full spectrum of U.S. immigration law. So don't hesitate to reach out to us if we can be helpful with any aspect of U.S. immigration law. That email that you'll get after this webinar will also have a link to our YouTube channel. And on our YouTube channel, we not only post our full-length webinars, we also post shorter videos. And again, those are on the full spectrum of topics within U.S. immigration. So if you have a question during today's presentation, feel free to send it to me through either the Q&A box or the chat function on Zoom. I will be monitoring both of those. We do plan to get through all the questions by the end of the presentation, so don't hesitate to send those in. And without further ado, I am going to go ahead and pass it off to Jiyae.
All right. Thank you so much, Dustin. And thanks everybody for joining us today. So let's talk a little bit about the basics of the National Interest Waiver requirements, the NIW for short. So the NIW is, in general, a subset of the EB-2 employment-based immigrant petition. An immigrant petition, as Dustin said, means that it is an application for a green card for U.S. permanent resident status. So a green card, and you may all know this, but gives someone the ability to live permanently in the United States and work for any employer or not at all. And having a green card also opens up the pathway to U.S. citizenship, if that is what you're interested in the future. Now, the EB-2 NIW in general is a popular choice among individuals who wants to apply for the green card on their own. And now this is called self-petitioning. You can apply as a foreign national individual, whereas normally for other categories, you would need a U.S. company to sponsor you for a green card and do what is called the labor certification requirement, which is that showing that there is no other qualified and available and willing U.S. workers to work on that particular position that is being offered. Now, if you qualify for the NIW, there is no need for all of that. There is no need for a U.S. job offer, and you can, actually apply as an individual. And that is one of the few categories for the green card that allow to do so. The EB-1A, the extraordinary ability green card, is another category that does allow self-petitioning. However, the EB-1A is a very restrictive and it's the first preference category. So the standard for someone to qualify as an expert who qualifies as one of extraordinary ability is very strict. So the EB-2 NIW can actually be a more viable option for a wider variety of professionals in various degrees of seniority in their industries who can show that their work will make significant contributions of importance to the industry or society in a broad way. And we'll talk a little bit more about what that means. So let's go through the eligibility criteria specifically for the EB-2 NIW green card. So the first thing to note is that each applicant must also meet the threshold criteria for the EB2 category itself. And this is a common threshold category for, both EB2 NIW petitions and also the regular EB2 petitions where you do have a job offer from a U.S. employer. So what is the threshold requirement? You can either meet the threshold requirement in two ways. So the first way is through showing that you have an advanced degree, which is defined as a master's degree or higher, or the equivalent of an advanced degree. And so you can be considered as someone who is the equivalent of an advanced degree holder if you have a bachelor's degree in your field and over 5 years of progressive work experience following your bachelor's degree. Now, what does progressive work experience mean, right? So progressive work experience means you have been tasked with increasingly senior duties and responsibilities as time went on. So if you worked for 5 years in the same position, the same title, same salary, and your duties never changed, then that unfortunately is not going to be enough to meet the definition of progressive work experience. So if you want to meet the criteria, the EB2 threshold criteria, with progressive work experience with your bachelor's degree, then you do need to submit a very detailed employment confirmation letter from your employer that really describes how your duties change over time to really show the USCIS that your duties have changed in complexity, seniority, and in level. So then let's talk a little bit about the other way you can qualify for the EB2 threshold, which may apply if you do not have, a master level advanced degree, or if you do not have that bachelor level degree, and 5 or more years of progressive work experience. And now, what I did forget to mention is when I say master's degree or master level degree or above, degrees such as a JD, a Juris Doctor, or an MD, medical doctor, also qualify as advanced degrees because you typically will already need to have a bachelor's in order to access those graduate programs. So for example, and other degrees such as an MBA as well, right? An MBA, LLM, those kinds of professional degrees can also count as a master's level degree, an advanced degree, if you typically need a bachelor's degree to gain admission to those kinds of programs. So the definition of master's degree is actually a little broader than you think. And obviously PhD degrees will qualify. But let's now talk a little bit about exceptional ability. That is the other way you can qualify for the EB2 threshold if you cannot, present that kind of advanced degree or equivalent of an advanced degree, right? So the way to prove exceptional ability is to meet 3 out of 7 criteria that the government lists here below. But also, cumulatively, the evidence that you have must show that you are someone who has a degree of expertise that is, quote unquote, significantly above that ordinarily encountered in the sciences, arts, or business. So what does this mean that you have a degree of expertise that is significantly above that is ordinarily encountered? How do you prove that? So you can prove that by, gathering all of the evidences that not only meet those criteria, but also show that you are someone who is outstanding. So let's take a look a little bit at the criteria. For example, if you have 10 years of experience in your field full-time, you can prove that with showing employment confirmation letters from your previous employers. What about a related degree? If you have any degree that is related to what you're doing, even if it is not a bachelor's degree, even if it is not a master's degree, you can you can show that as confirmation that you have had specialized training in your field. What about a related license? That can also be helpful in showing that you have those outstanding skills, especially if it is a higher level license. Membership in professional associations and proof of, even taking leadership positions on those professional associations could be a helpful form of evidence. And what is important really here is to really show that you have had recognition in the field for outstanding work that you have done, exceptional work you have done that really sets you apart from the majority of what is ordinarily encountered in the field. So what can that be? For example, if you have won any awards in your field, been recognized in, if you won, best paper award at a conference, for example, in your field of research. What about if you have made a new invention in your field using new technology and you have actually published a patent for that. Publication of patents can also be considered as a significant, recognition for the innovation of what you have done. So you can really be creative in thinking about what kinds of evidence could show really that you have earned this recognition. And this can also take the form of expert letters from, people in government, people in academia, fellows in your industry who can really attest to what you do differently than what is ordinarily encountered in the field. Finally, there are other types of evidence you can show, such as having a high salary as compared to others in the field. So really the thing to note is that cumulatively looking at the evidence as a whole, you must really be able to prove that you are someone who is operating, who has a degree of expertise that is significantly above what is ordinarily encountered. Now, after meeting the EB2 threshold, really the main challenge, the meat of the petition, is showing that you qualify for the NIW. Because if you don't show that you qualify for the NIW, the government is going to think, okay, just go through the ordinary labor certification requirement, right? What the NIW does is exempt you from the ordinary labor certification requirement, which is a requirement that a U.S. employer must test the labor market to see if there is a qualified, able, and willing U.S. worker to take your spot. But if you can show that your contributions are so significant to the field, so significant to the national interest, the government can actually exempt you from that and say, okay, well, this time you don't need a job offer. You don't need to show that another U.S. worker is not available because on balance, the nation would benefit more from having you work here, even if it means taking a job from another U.S. worker with minimum credentials. So that's kind of the logic behind the whole NIW process. So what are the three criteria? And these criteria was promulgated by a case law called Matter of Denisar in 2016, and it is a three-prong criteria. And you need to meet all three prongs in order to qualify for the NIW. So the first criteria is that the applicant must be able to prove that their proposed endeavor has both substantial merit and national importance. Now, what does that mean? What does substantial merit mean? So this can be proven in a range of fields, including the arts, the sciences, business, and even culture, right? And endeavors that usually, tend to advance human knowledge in a particular field are favorable for finding of substantial merit or have any kind of, positive influence to society. Now, what about national importance? Now, what the government is looking here is what is the potential impact of your work? Does your work stand to only benefit your immediate customers or clients? For example, are you opening a pizza shop and will it only benefit your business and or the clients who use your services? Or are you doing something that has national or global implications, broader implications for the advancement of a particular field as a whole, right? Such as medical advances, that is one example the government cites in the case law, or improved manufacturing processes, which can really result in increased efficiency and increased technology for, a broader impact that you can see in the economy as a whole, a substantial positive economic impact. So the breadth and the extent of the impact that extends beyond your immediate clients or immediate employer is really the key in proving national importance. Now, the second prong is that the applicant must be well positioned to advance the endeavor. And what does this mean? It means that the applicant must show that they have the education, the experience, and really a record of success that is related to the project that they're proposing to do in the United States that positions them well to do this work. Now, then let's move on to the third prong. What is the third prong asking? The third prong is asking for a showing that on balance, it would be beneficial to the United States to waive the labor certification requirement for that particular applicant for that particular project. And you can prove this in multiple ways, right? So you can emphasize the first prong and really focus on the broad and systemic benefits that your proposed work in the United States has that is really bigger than the ordinary benefits of the labor certification process, which is the policy of protecting one job for one U.S. worker who may replace your spot. The other strategy you can have is to really focus on prong 2 and talk about what are the unique skills and irreplaceable experiences and know-how that you only have that other people who are working in your field don't have that you can bring some sort of innovation to the field that will really result in, improving best practices for the field as a whole. Because if you do something new and other people copy you, then you can really have a broader impact. And that can only be done by you if this is your unique approach that cannot really be replicated or replaced by what another worker could do. And another thing to note for entrepreneurs in particular is that for many business endeavors, really the job creation potential in the United States could be much greater than the benefits of securing one job spot for a US worker, right? So what if you're an entrepreneur and your business has already created dozens of employees, US jobs, and what if you will create more jobs as you continue to develop your business? You can clearly see that on balance, having the entrepreneur here to develop their business and actually be creating dozens and dozens of more jobs obviously has more benefits than the ordinary benefits of saving one spot for one US worker. So those are some of the strategies you can use to compellingly prove the third prong. All right, so now let's talk a little bit more in depth about how the NIW can be used for entrepreneur cases in particular. So the previous case law was what's called New York State Department of Technology Transportation, really focused on the national scope of the endeavor. So the geographic scope was a very important part of judging national importance. Now, with the new case law, with matter of Danisar, the government actually moved away from this previous focus on geographic scope, which means that a business endeavor can qualify as an endeavor of national importance, even if it's located in one particular state, even if it is located in one particular region and the benefits are localized there. It can still meet the national importance criteria as long as you can show a broader impact to the field, or otherwise qualify for national importance through other means, such as economic revitalization of a particular depressed region that you can prove with, letters of intent from the local government in saying, well, this particular endeavor is very important to this revitalizing this economically depressed region. That can actually, also qualify as a matter of national importance, even if the benefits are localized in that geographic area. So this focus away from geography to more, looking qualitatively at your contributions really opened the door for many entrepreneurs to apply. Now, another thing that changed with the new matter of Danisar case law is that the AAO very specifically recognized that entrepreneurs are self-employed, and often they're not eligible for a green card using traditional approaches. So what this did was really, the court has specifically recognized that the NIW could be a viable option and could be an appropriate option for entrepreneurs, given this disadvantage really that they have by having an ownership in their company that will disqualify them, that may very well disqualify them from using the ordinary labor certification process because of their ownership in that company. Finally, the matter of Danisar case law specifically notes that entrepreneurial work can lead to an NIW, and really shows examples of that, and even states that the planned venture in the United States does not need to ultimately succeed to merit a green card. It just, the applicant just needs to show that it is plausible that the impact of this entrepreneurial endeavor will have national importance, and it is plausible that it may succeed. All right, so now let's talk a little bit about some strategic considerations when you are considering applying for immigrant petition through the EB2 NIW pathway. So first, let's talk a little bit about timing. How long does it take to get an answer on an NIW petition? So great news, great change that came down over the past years is that premium processing is now available for NIW applications. It used to take an entire year to get an answer on the NIW I-140 part alone, which is really the part one of a green card application to really prove your your eligibility for the green card. Now, with premium processing, the government could take an action on your case within 45 days. So if you pay for premium processing, the government will get back to you within 45 calendar days. So it could either be a straight approval, a decision. It could also be a request for evidence, or it could also be a notice of intent to deny. And once you get the RFE or NOID, you will have that time to prepare your evidence and prepare a response. And once you submit the evidence for in response to the RFE or NOID, the government will then take another 45 calendar days to respond to you. And mind you, they can respond to you sooner than 45 calendar days. So the 45 calendar days is a cap, but we have seen many, many cases where the approval, for example, has been issued much quicker. We have even seen cases that are approved in 2 days after being received, weeks after being received, a month after being received. So there is a little bit of variety, but it is very, very possible that you may get an action before 45 days is up. So premium processing has really changed the landscape for a lot of our applicants. Now let's talk a little bit about the underlying visa status issue. So it is very important to note, if you are considering applying for an NIW, is that it is an immigrant petition. And whenever you file an immigrant petition, to a certain degree, you are representing to the government that you do have some intent to immigrate to the United States as green card holder sometime in the future. So for example, if you are on a non-immigrant visa that does not allow for dual intent, once you file the I-140, it may complicate a little bit on your ability to renew or extend this visa. And this may be, a more salient problem if you are actually, applying for a visa stamp at a consulate, because, consulates would know that you have filed an immigrant petition on your behalf. And, let's say if it is approved, then it may really signal to them that you have immigrant intent to become a green card holder in the United States. So what can you do? One strategy element to consider is the timing, right? So if you are preparing to file an NIW I-140, and for example, if you're on a TN visa, for example, and if you are due to renew the TN visa soon, maybe it is a better idea to renew the TN visa first. And then once you have the 3 years on the TN visa, after that, then maybe you can, file your NIW to, have this strategic, timing of things that could really be an important question to consider, given these risks. Other visas are not affected by this immigrant intent issues, such as the H-1B visa, for example. It is a dual intent visa. The L visa is also a dual intent visa. The O is also, to a certain degree, dual intent. So if you're on an O and if you apply for an NIW, you may be less subject to those risks. There is always a risk when you are, applying for an immigrant benefit, but for those types of visas, you're not subject to that. So what is the application process for getting a green card under the EB2 NIW category? So it is worth noting that the green card process has 2 steps. The first step is the underlying petition, the underlying immigrant worker petition, the I-140, to prove to the government that you're eligible for that particular visa category, right? So the first step is to submit the form I-140 with the proof that you meet the EB2 qualifications, and also evidence that you meet the NIW qualification, the 3-prong criteria that I described in previous slides. Now, there's a thing called the priority dates. And if you look at the table that the government publishes every month, it's called the Visa Bulletin. You can even Google that. If the table says C on the particular category that they're listing, it means the category is current. Now, what it means if the category is current is that if you're in the United States on a different non-immigrant visa, you may be able to simultaneously file your I-140 and also the I-485, which is the application to adjust status to a green card holder. So that is what I call step 2 of the green card process, where based on the I-140 approval, they will evaluate if you qualify for the green card and actually will issue the green card at the end of the I-485 process. Now, if the category is current, then you can file both applications simultaneously. Now, currently, though, the category is not current for the priority dates are not current for the NIW EB2 category. So what this means is you first need to file the I-140, and once you have the approval, and if your priority dates are current by then, according to the threshold, then you can file your I-45 if you're still in the United States, or if you're outside the United States, you would apply for an immigrant visa at your home country consulate instead, which means you will appear for a visa interview at the foreign country consulate and get what is called an immigrant visa stamp, right, in your passport. And once you get that, you will re-enter the United States with that immigrant visa, and you will land as a permanent resident, and they will mail your green card to you. So that is the process that you will need to go through, the two-step process. And what is the timing for the I-45 or the immigrant visa petition? I would say, give or take a year on average for the I-45 to be processed as well. And unfortunately, the I-45 part cannot be premium processed. So definitely look for what can be a prolonged timeline, especially given the delays in priority dates that we have been seeing. So there is a backlog where you are not allowed to immediately apply for your I-485. Right, so the final topic here is pros and cons of adjusting status in the United States versus consular processing. So I alluded to these two options. The I-485 is the option if you're already in the United States. You can choose to adjust status to a green card holder within the United States. Consular processing is if you're abroad right now, if you're not in the United States currently, then you need to go through consular processing to apply for an immigrant visa, do the interview, and then come in with your immigrant visa. If you're in the United States, you have the option to either adjust status or to consular process. So you do have that option to choose. The pros of adjusting status in the United States is that it gives you a basis to continue living in the United States while your I-485 is pending. Because it is very important to note that just filing the I-140 does not give anyone an independent basis to continue living in the United States if your underlying visa, non-immigrant visa status has expired. However, if you file the I-485 while your underlying non-immigrant status is still valid, then you can continue to live in the United States up till the point that your I-485 is adjudicated. So if that is your goal, then the I-485 could be a good option for you. Now, one disadvantage of the I-485 is that while the I-485 is pending, and what you can do is you can also apply for what is called an advanced parole, a travel authorization, and employment authorization card so that you can work while you're waiting for the I-485 to be adjudicated. Before you have the travel authorization, what happens is you can be stuck for a little bit of time in the United States while your I-485 is pending and before you have the travel authorization. And the reason why is because if you leave the United States while it's pending, then it will really be, you're abandoning the application. So if you travel abroad outside of the United States, you will actually lose the I-485 that is pending if you travel without your travel authorization. So that is the risk, right? So if you want to avoid that risk, then the consular processing could be a better option for you. Just note that if you choose consular processing, you do need to maintain your underlying visa status in order to continue staying in the United States, right? So if you're on an E2, then you continue to extend the E2, continue to get the E2 visa while your consular processing application is pending on the side. Yep, that's pretty much it. Now, let's talk a little bit about some updates that the government has announced regarding how they assess, NIW petitions for STEM applicants and entrepreneurs. So regarding the STEM-specific guidelines, really the key to note here is that there is more guidance now on what are the particular STEM areas that the government thinks are important and are favorable in meeting the national importance prong. If you are engaging in, work that aims to advance those technologies in the United States or aim to really improve best practices and help the United States get more competitive in those kinds of critical areas, right? So what are these areas? And those are what is called critical and emerging technologies, right? And the government government publishes, reports. I think there has been 2 different versions that the government has published with regards to the list of the CNET technologies, but I can read to you what some of these include. So, for example, advanced computing, advanced engineering materials, advanced manufacturing technologies, advanced sensing technologies, aero engine technologies, agricultural technologies, artificial intelligence technologies, autonomous systems, biotech, communications and networking technologies such as 5G networks, large-scale data science and storage technologies, distributed ledger technologies, energy technologies, medical and public health related technologies, quantum science, semiconductors, and space technologies are some of the examples that the government lists in the critical and emerging technology list. And to the extent that you are well positioned and that in your proposed endeavor seeks to advance these technologies in a broad way and not just end up benefiting just your employer or your immediate clients. If you actually are doing research and development, R&D in those critical areas, then you are very you could be considered as a very favorable candidate under these specific guidelines. Now then, let's talk a little bit about the updates to the entrepreneur-specific guidelines that also came down in 2022. And what is the important key to note here is that the government lists some specific types of evidence that entrepreneurs can rely on, even if they do not have the traditional metrics of national importance and well-positioned as, usually you would see in a typical case. So for example, lists of publications and citations and things like that for researcher types that may not be applicable for a typical entrepreneur application. So there are other types of evidence that an entrepreneur can rely on to nevertheless show the broad impact of their work, their prospective work, and also to show how they are well positioned to advance this endeavor, even if they do not have any publications, even if they do not have any citations, right? So let's look at a couple of examples. If the petitioner can show significant media attention on their project, for example, or their particular business startup, right? So even if your name is not mentioned in a media article, but you're the leader of a startup, if you're an executive in a startup that has been mentioned as a startup of notable merit in industry publications, industry shortlist, and things like that, you can certainly use that as evidence of national importance and substantial merit. And what about awards and grants, right? And some types of funding that you can get from venture capital organizations, for example, can also be used by an entrepreneur to show merit, substantial merit, and national importance. Even if a reputable U.S. VC, organization is choosing to fund your project, that can independently be considered as a validation of the potential of your business idea. Letters from third-party industry actors. So let's say your startup idea was selected for a prestigious accelerator or incubator, like Y Combinator, Techstars, or things like that. Definitely, you can get a letter from that particular incubator and prove why this particular project has the disruptive potential to increase the competitiveness of the U.S. Field as a whole in that particular sector. Letters from government agencies expressing their support in the particular business project. And for example, if your angle is your contributions to an economically depressed area, then you can definitely get a letter from that particular region, and that government letter can confirm why your business has the potential to really revitalize that region and why it has such importance for that particular region. And that can certainly support your argument for national importance. And that goes to records of job creation as well. You can show history of job creation if you have been running your company in the US for a while. And if you have seen significant growth, you can prove that to W-2 records with regards to employees, tax returns with regards to revenue generation. If you can get a high valuation from an independent organization that can, estimate the value of your company. And if you can get a high valuation for that, that can also help in expressing the substantial merit and national importance of your business endeavor. Similarly, for well-positioned, there are alternative forms of evidence the entrepreneur can use that is different from the typical case for a professional, right? So if you have ownership and critical role in the U.S. entity, that in itself can help the well-positioned prong. If you have evidence of people wanting to invest in your project, and I have mentioned that in the context of national importance as well, that can also support well-positioned because you must have done something right to get those letters of intent from industry leaders who want to back up your project. Intellectual property, if the company has signed up for a patent for its invention, or if you are listed as an inventor in a patent, or even if the company itself is the owner of the patent, you can use that in saying that, hey, I developed this technology, therefore I'm well positioned to continue to develop that. Media attention, history of revenue growth, letters from third parties, such as, venture capital organizations and leading accelerators and incubators. All of those can be great forms of evidence to support the NIW petition for an entrepreneur. All right, so then let's talk a little bit about the process of preparing for an NIW submission. What are some of the things that are included by way of evidence? So the first category of evidence is you do need to include the proof that you meet one of the threshold requirements. So for example, if you're meeting it through advanced degree, you can submit the diploma showing that you have the degree. Also, if it is a foreign degree from a foreign institution, you may want to get the U.S. education equivalency report that really confirms that the level of the degree that you got is equivalent to that particular level degree in the United States. If you're meeting the advanced degree through showing your bachelor's degree and 5 years of progressive work experience, as I mentioned before, definitely you need to get the employment confirmation letter from your employer to show how your duties have changed in complexity and your responsibilities became more in seniority over time. You want to have that proof to really show that you meet that requirement. If you are meeting the threshold through exceptional ability, you need to present evidence meeting at least 3 out of the 7 criteria that I mentioned before, and also make sure that the universe of evidence that you submit in support of exceptional ability show in totality that you are someone who is operating at a level that is significantly above what is ordinarily encountered. Now, the other part of an NIW petition is you really need to collect a volume of evidence to show that you qualify for an NIW. To show evidence under the 3 prongs of matter of Danisar that I've just explained in previous slides. So let's say, for example, national importance. You may want to get expert letters from government institutions, government officials, tying in your work to the national interest. You may want to gather third-party articles and government executive orders and government reports that really confirm that the United States is really keen and interested in seeing advancement in a particular area that you're working in that is relevant to your proposed endeavor. You really want to present a strong business plan if you are an entrepreneur to really show the government what you're intending to do in the future with your business and what is the prospective impact that your business can have on the economy as a whole, and also what contributions are you making to the field. Are you bringing in a new invention? Are you bringing in a particular way of innovation in a field, and what is the impact we can see from your particular project? You want to make sure that the business plan covers all of those details and also backed up by independent expert letters. So yes, I did mention the expert letters here. These letters may be used to demonstrate substantial merit and national importance of your work. And also these letters can talk about your record of success in previous projects that position you well to advance this endeavor. So those letters can also support the second prong as well. So expert letters can play an important role here. Your resume and degrees proof of professional accomplishments such as awards won, patents published, presentations you've done at conferences, industry and media recognition. All of those things would be very important to show the impact of your past projects, previous projects, a record of success before you started your current project in the United States, to support the well-positioned prong, right? So to show that you have the relevant education, experience, and knowledge to make your project a reality. So you do need to present evidence of that as well. With regards to entrepreneur cases in particular, if you have contracts for high value projects with leading industry actors, such as if you are an architect and you designed the headquarters for Google, for example, obviously that is something you want to highlight, proving that leading industry actors in the United States are interested in your work. That could definitely be helpful. Letters of intent and proof of startup capital. If you got investment from an incubator accelerator, for example, you can show proof of that by showing the stock purchase agreement or loan agreement or things like that. So you do want to collect the objective evidence of interest from industry and government actors that is likely to show that your project will be successful. All right, so the last topic we will cover is a little case study that we will introduce for entrepreneurs that gives kind of a more concrete idea on what a successful case for an NIW can look like. So for this particular case, the applicant was an entrepreneur who proposed to form a small consulting firm that will do some programming work and project development work in partnership with U.S. government entities and U.S. philanthropy organizations active in the area of veterans welfare, right? So let's look at the three prongs then. So for substantial merit and national importance, what was the argument here? So the applicant, an entrepreneur, proposed to set up this consulting firm, and they proposed to coordinate projects that was likely to facilitate the reintegration of returning veterans and wounded veterans into productive society. So the problem that the business was going to address was that there is a lack of connection between wounded warriors, returning veterans, and productive job opportunities that could really help them reintegrate and access better resources to do that. So how did he prove that his project has substantial merit and national importance? The first thing that he did was to submit a detailed business plan, right? And in that business plan, there was a very concrete plan on who this person intended to collaborate with, what kind of projects this person intended to, organize, and importantly, how this would improve the existing status quo in having this disconnection between veterans and productive work opportunities, right? And these plans were made even more credible because it was supported by letters, expert letters from prospective clients, describing and really confirming how this person had the unique approach that could really help, the state of how things are done in veterans welfare, and how it will improve existing program offerings in those particular organizations. In addition to that, also was submitted government reports, news articles, and letters from relevant U.S. government organizations that confirmed that there was this lack in programming for veterans, and really confirming that this is a priority area for the government. And those government reports and government agency confirmations were really key to supporting that this issue was an important issue, towards proving national importance. Then now let's move on to well-positioned. How did this applicant prove that they were well-positioned to advance this proposed endeavor? So what really worked here was very detailed expert letters from very senior officials in relevant government organizations, relevant businesses, philanthropic leaders active in the field of veterans welfare that really gave very compelling, concrete examples of the past projects that this person had done. And not only did these projects contain the relevant detail. It also detailed the impact that these projects had on, pulling significant amounts of funding and connecting them with productive opportunities, and actually changing the lives of veterans, hundreds and hundreds of veterans. So the quantity and impact, the broadness of the impact of his work was really emphasized through these compelling expert letters. And of course, having the detailed business plan was also one of the things that helped, convince the government that he was well positioned to do this work, because, he had such a credible and well-developed plan. Finally, there was evidence that he had enough startup funding to make this project a reality. So having proof of funding was also helpful in this regard. Now, what about the third prong on balance? Yeah, we'll finish that up. Third prong on balance, it was beneficial to the United States to waive the labor certification requirement for that particular case. So in this particular case study, the government noticed that as a self-employed entrepreneur, it would have been impractical for this person to rely on the traditional labor certification requirement to gain the green card to be enabled to do this project, because he was the owner of his firm, right? And also looking back at the first prong, the prospective impact of this work, the government noticed the demonstrated value of the services that this person planned to provide to the veteran population, and, emphasizing the second prong, the track record of success in the field from his previous projects that was demonstrably large. So on balance, the positive impact that this person would bring to the veterans' welfare and society as a whole was much larger than the ordinary benefits of saving one spot of job for a U.S. worker. And so it was really a no-brainer for the government to approve the NIW in this case.
Perfect.
Right.
Well, Jiyae, thank you so much. We do have a few questions that have come in. And for those of you on the webinar, if you have any other questions, feel free to send those in while we're talking through the questions that have come in. So Jiyae, as a master's degree holder, do I need to show any work experience in my profession at all? If not, would it have any negative or positive effect to show it anyway?
Great question. So if you have a master's degree, you don't need the work experience to meet the threshold requirement. However, I would highly recommend, if the work experience is related to your proposed endeavor, it is a good idea to include your CV anyway, and include examples from your previous work experiences when you are putting together the evidence for well-positioned prong, because the applicant experience, education, all of it is relevant in meeting the well-positioned prong. So even if you don't need it for meeting the threshold, you may end up wanting to rely on it for the well-positioned prong.
Perfect. You mentioned letters from previous employers. What if you have left the employer and you're not able to get a letter from them? Would it be possible for a colleague at your present employer to give you a reference letter?
So for meeting the employment, so for example, if you're trying to meet the threshold requirement with the bachelor's degree and 5 years of work experience, you do need some letter from the employer to at least prove that you worked there. And getting a letter from someone who previously worked there, I think less favorable, right? Because they would want to see, an official letter from that company proving that you were the employee before. If you have pay stubs or other things like that, you may be able to also use that, but that's more like, that's a lesser favorable type of evidence. You really want to try and get the letter from your previous company. Now, if you are trying to use some of these letters to support the well-positioned prong, then you may be able to use testimonials from previous people that you worked with that are no longer with the company. So that is possible. But for the threshold requirement, the EB2 threshold, you will probably need at least a very basic letter on letterhead that confirms you work there, and maybe you can supplement that with a letter from a previous colleague who, if they're no longer with the firm, they can at least maybe provide some from some narrative about your duties and how they were progressive. So maybe you can use a combination of those two letters. So yeah, you can definitely think about those options.
Great. So I know some of you are raising your hands. If you have a question, go ahead and send it in through the question and answer function or the chat function on Zoom if you can. All right. So this question is a multi-part question. They share their background, citizenship, and they ask if they can apply for an NIW. Please schedule a consultation on our webinars. We don't talk about the specifics of your circumstances. We try to keep it to questions that are generally helpful to the audience. But the second part of the question is, what is the processing time for an NIW? So Jiyae, could you just give us a sense of start to finish what the processing times look like?
Sure. So I can also go through how much time it typically takes to prepare a petition. So on average, we would say like, yeah, 2 to 3 months would be really the minimum on how you would spend time gathering all the evidence and preparing the petition. And then once you submit it, right after the USCIS receives the petition, if you pay for premium processing, they will get you an action within 45 calendar days, right? And if you get a request for evidence, you would prepare, the request for evidence, and then you would submit the response, and they will take another 45 calendar days to get you the decision, up to 45 calendar days. So that can, also, the processing can also, take some months. And if you don't use premium processing, if you use regular processing, it'll probably take about a year to hear back on the I-140, either with a decision or RFE or NOID or anything like that. So you can, calculate that first. And then once you have that approval, right? And as of now, from filing to the priority dates becoming current, the backlog, which means, because there are a limited number of immigrant visas issued every year, the backlog is about a year. So we have seen people who filed in, for example, February 2023, they're like only now like becoming current and they're able to file. So that delay you also need to take into account. And now what happens after you file the I-45? As I mentioned before, there is another year that you need to wait until you get an answer on the I-45. But the good thing though is the work authorization card comes through pretty quickly. So let's say you get the work authorization card in 3 to 4 months. Then after you file the I-45, and once you have the EAD, the employment authorization card, you can work for any employer you want up till the point that you get a decision on the green card. So it may not be as painful as you may think it is, because the I-45 actually gives you some good options.
Perfect. Let's see. So tell us about dependents. So if you apply for an EB2 NIW, your dependent children, dependent spouse, what do they get?
Right. So dependent children, dependent spouse are also eligible for the green card with yourself. So if you qualify for the NIW and if you qualify for the green card, your dependents also have the right to apply for a green card alongside you. So that can be a significant benefit. Now, keep in mind that there is an age limit, right? So if your kids get married or age out at 21, then they can't, qualify for that. So if that can be one of the reasons why you may want to apply earlier rather than later. So that's another timing consideration.
Absolutely. All right. So support letters. Can you use support letters that are given to you from colleagues with the same title, or should your authors of the support letters hold a leading position?
It is more favorable if they're from supervisors. If they're from peers, it's, not as favorable. But it really depends on your position, right? So if you are the CEO, right, then obviously you would get a letter from a partner. So it depends on your particular case. But usually, for example, if you're an engineer at a firm, then you would want to get it from your supervisor.
Great. And Jiyae, I know you've gotten this question before, but recycling letters is if you got a letter from the employer in the past, can you reuse that letter? Tell us about that.
I think it depends on what you're using the letter for. So if you're using the letter to just prove that you have, 10 years of work experience for exceptional ability purposes, then yeah, you can use that letter to prove the simple fact that you have worked for a particular employer for like 3 years, 4 years, or what have you. But let's say if you're trying to prove progressive work experience, and let's say if that letter doesn't say anything about how your duties change over time, then you unfortunately can't use that, right? You would either need to have an additional letter to support that particular detail, or have a new letter from the employer that includes that particular detail. And it depends on what you're trying to prove. So let's say you're trying to prove that you're well positioned for that particular proposed endeavor because of your experience and your specialized skills and your contributions to the field. In that case, if the employer letter doesn't have enough detail that speaks to those things, then it will not really be useful. So in that case, definitely a good idea would be to get a new letter.
Perfect. This webinar, I got a question about the recording. It is being recorded. You will be able to view it on our YouTube channel, or we will send you a link in an email following up on the webinar. So do keep an eye out for that. And finally, Jiyae, so interesting question. You're working for a company that has a branch in the US and another location in Canada. Can the Canadian office give you a reference letter and indicate you'll be given a spot at the US office if your NIW application is approved?
Well, no, since the NIW doesn't depend on a job offer, like I'm not entirely sure how useful that would be, or what, in what way we can use this evidence to your benefit. So I guess, yeah, definitely schedule a consultation to so that we can look at the specific facts in your case. But there is really no limit to who you get the letter from, depending on what you're trying to prove, right? So if you're trying to prove that you're well positioned to advance a particular proposed endeavor, you can definitely get a letter from your, employer in the past in your home country. Like if you're Canadian, if you work for a Canadian firm, you can definitely get, a support letter from there. So there is really no nationality limit on where you get the support letters from, as long as they're relevant. So in the veterans example that we discussed earlier, a lot of the applicants' support letters were from UK individuals because this person was active in UK before they, proposed to work in the United States. So definitely it is very common and possible to get a letter from your home country.
Perfect. And finally, I think there's a little confusion over the employment letters. So the question is, do I need employment letters from all of the companies I mentioned in my resume? What if some of those companies have shut down? Should I just remove that company from my resume?
Right. So that is a very good question. There is no need to prove your entire employment history. That is a common misconception. Only if you're trying to prove that you have 10 years of experience, for example, that then you just need, enough to prove enough work experience to meet 10 years. But that's only if you're trying to meet exceptional ability, right? If let's say if you're trying to meet, advanced degree equivalent by showing 5 years of experience and a bachelor's degree, then you only need to show 5. So you definitely do not need, in all cases, to prove every single item in your resume with reference letters from your employer. So that is not necessary. What can be helpful is to bring out the experiences that is relevant to your proposed endeavor for well positioned, right? But in that case, you don't, if you're using the letters for that particular purpose, you may not need someone who is currently active at the company. It could be a former colleague. So there is some wiggle room with those things. So definitely work with a lawyer who understands their requirements. With regards to hiding things from your resume, well, there is no requirement that you need to list every single thing in your resume. But if it is relevant, you should generally list it. And the government will not require you to prove every single item in your resume. So definitely you don't need to go through and get a letter from a company that has closed if that is impossible.
Great. Well, Jiyae, thank you so much to our participants. Thank you very much for the great questions. We do hope that you'll keep an eye out for that email, and hope you have a chance to view our future webinars. And reach out to us if we can be helpful. If you have a question about your particular case, reach out, schedule a consultation. Jiyae or anyone on our team would be happy to speak with you. Jiyae, thank you again for sharing your expertise. Everyone, have a great day.
Thank you, everyone.